Prosecution, Ethics, and Conflicts. Today we have Chad Swantz. He's a patent attorney with Suiter Swantz. And we also have Tyson Benson, who's an IP attorney with Advent. And so I believe Chad is going to start us off today. Thank you all for being here.
Good afternoon, everyone. My name is Chad Swantz. I'm going to try to keep this as light and easy as possible. It's obviously a fairly dry subject, but we're going to do our best to enjoy it and learn something along the way. Just kind of by a show of hands, how many people are not patent attorneys? 1, 2, 3, 4, 5, 6. Okay. Well, the patent attorneys outnumber the non-patent attorneys, but I will hopefully try to describe the issues that patent attorneys face in a way that everyone will understand, and everyone can learn the ethics associated with a patent attorney. So patent attorneys must follow two kind of separate and distinct guidelines for operating as an attorney. The first one is the model rules or the ethical requirements associated with the state bar in which he or she is licensed. Secondly, the Code of Professional Responsibility of the United States Patent and Trademark Office, as listed in 37 CFR Section 10. So within the USPTO, we have 10 canons of expected professional conduct, and there's 4 that I've listed that are kind of serve as the foundation for what we're going to discuss. Canon 4, preserve confidences and secrets of our clients. Obviously, that is something that is true for any attorney, and is something that seems somewhat fundamental. I don't know about you guys, but when I'm in a social situation and I am meeting new people and they come to know that I am a patent attorney, the question that they always ask is what is the coolest invention that you're working on in the last 6 months? And I like to be able to answer that question, but obviously this particular canon is something that we're not allowed to do that. And if I happen to be at a party and I've had a few beverages that are only to be consumed by adults, then I'm even more cautious on what I'm going to say. So if you don't want to obviously come across as being non-sociable, but I always like to have somewhat of a canned response ready to go whenever that issue might come up. Canons 5, 6, and 7 kind of refer to the basis in which we're going to operate with kind of a clear mind and a clear conscience. Canon 5, we're going to exercise independent and professional judgment on behalf of the client. We want to represent the client competently, and finally, zealously within the bounds of the law. So from these canons, particularly canons 5, 6, and 7, we have what's known as a subject matter conflict of interest. And that is the topic that Tyson is going to investigate and analyze, in particular in the case study that he has prepared for the second half of today's presentation. What is a conflict of interest? A conflict of interest can arise between clients or potential clients when working in areas of related subject matter. Obviously, when a conflict exists, it can make it a challenge for an attorney to fulfill his or her duties to a client in an impartial fashion. And I think like at this point, I'd kind of like to open it up to everyone. Has anyone faced a subject matter conflict of interest that they have dealt with that they can disclose and share with everyone? I will get it started since I see so many hands. The issue that I face is I had a small client, individual client, who's does a lot of work with hunting devices, and he came to me, and he had a I will call it a hunting device, which allowed and attracted birds, I think they were turkeys in this instance, to come to the area and draw their attention. And there was some fairly unique aspects in which his particular device operated. And this was at an initial meeting, and the idea was that he was going to put together the kind of specifics of what he was going to include, and we were going to work together to prepare a patent application. The following week, another hunter who had also been in the business of kind of developing similar devices came to me with a very similar idea, and I mean, it was almost uncanny how similar the inventions were to the other T. It was almost like maybe they were at the same party, and maybe they were sharing stories and they just didn't know it. But in that instance, what I did is it kind of freaked me out, and so I wrote it as much information as I could to try to remember all the specifics, and then I asked both of the inventors to find other counsel. And unfortunately, you know, in thinking about it since that time, you know, I kind of think that the best thing that I could have done for both of them really was to pair them up and let them share their resources and do what they could together, and they would have been able to have the most success. But obviously, you know, our ethics guidelines don't allow us to do that, and so that is my war story. Anybody else want to share one with the crowd?
I'll go ahead. I had one just recently. I have a standing pretty large client who works in the area of conflicts. I had a small client, better relationship with my current client several years ago. He's a smart guy, and he came up with this invention. Called me up. He lives in Italy. And, started working on it. He never really would disclose the exact invention, or this kind of general area, so I wasn't too worried. As soon as I got a disclosure, though, actually detailed several of the references he cites in terms of background material and that were my clients. And, so I kind of immediately just closed it. Told him that he needs to find other counsel. I helped him do that.
So the question or the story from the crowd was that he was working with a large client and in the field, and a particular inventor left that large client and went off to do some work on his own. And now that particular person who's doing similar work as the large client wants to engage the same attorney to do similar work, and obviously that's a basis of the prior relationship. And Matt, how did you resolve that matter?
Honestly, I as soon as I got disclosure, I actually didn't do the whole thing. I read kind of summary, list of references, a general idea of the inventions directed to. It's too close to my clients to do it. So, in retrospect, in light of the recent case law, would there have been a technical subject matter conflict? Maybe not completely clear, but I mean, I decided safety and then
Sure. So what he did is he referred the small client to another attorney after not even taking necessarily a deep review of disclosure and the related material, and obviously that is good for ethics, but maybe not necessarily good for business. So, and that kind of gets me to, and it's a good lead-in to the dilemma of a patent attorney, and this is kind of directed to some of the folks that aren't necessarily patent attorneys. So what ends up happening is, like I'm an electrical engineering person for undergrad, but people come to us with inventions in all sorts of technologies, and chemistry, for example. Well, I don't know a lot of chemistry, but I can do some work in order to try to learn some chemistry and learn certainly to the level in which I can help my client protect their chemical-related inventions. And so what often happens is I become skilled in an area which I wasn't previously skilled. However, after that time, and in the case of Matt's scenario, oftentimes inventors that you've developed a relationship will either leave to go start their own company or will work for a competing company. And the fact that you have worked with that inventor before and have developed a rapport, that inventor may want to work with you in the future. And so what happens is, from the patent attorney side too, is, I've spent a lot of time trying to learn chemistry. There's a reason I am not a chemical engineer. I'll Dan Hans and probably a few others in the crowd. And so, by doing that, I want to leverage that time and that experience that I have, but obviously can only do so to the level in which a subject matter conflict doesn't exist. Does that make sense? Or anybody have any questions kind of about that? So the USPTO has some rules with regards to subject matter conflict inference, and it is along the lines that a practitioner shall decline proffered employment if the exercise of the practitioner's independent professional judgment on behalf of a client will be or likely to be adversely affected by the acceptance of the proffered employment, or if it would be likely to involve the practitioner in representing differing interests, except to the extent permitted under paragraph C of this section. There's one aspect on that I'd like to discuss, and what happens in the normal course of a patent prosecutor is that you don't necessarily become aware of the conflict at the time that you're presented with the new work or the employment as listed in this rule. So what happens is even though you've done some work with a particular technology and you see that a new inventor is coming to you with something that might be similar, well, all inventions on some level are similar, and you don't really know to the level or the extent of what the subject matter conflict might be, possibly until the patent office has completed their examination and they have now cited a reference in which you were the possibly the attorney that handled the patent or the patent application, in which forms the rejection. So these rules, I think, in English are very easy to understand. In practice, I think they're difficult or can be difficult to follow at times. Yes, Ryan.
So what's your perspective on when multiple references are cited in office action, you have to be the client, when you respond to the office action in a manner that is not, either you don't have to amend the claims, you don't have to argue against those references, just the mere fact of them being cited within an office action, is that enough to create a conflict where you should part ways on it, or if you can respond in such a manner that it doesn't adversely affect either party, do you move forward on the response? And have you had that happen?
That's a great question. So the question was, so a patent application has been filed and the patent office has rejected the application over a plurality of references, and maybe one or two of the references are owned perhaps by the same client as yourself. And okay, thank you. Repeating the question, so it's the references and the application itself too are owned, or there's. Okay, thank you. So you're representing your client, and another client's references have been cited in the rejection of the case that you're currently prosecuting. And I would say, for the way I have handled that, is a variety of ways, often dependent upon what the client themselves feels with regards to that conflict. One of the factors I think that's an issue is whether or not you have personally prosecuted that reference that's being used against you and your other client. I think at some level that seems to, if you have specialized knowledge of what went involved in the development of that case, I think that's certainly a factor. But if it's a case in which you have no specialized knowledge other than what is presented in the patent application itself or what's available within the prosecution history, I think that's a different perspective. But the short answer to your question is I think it depends, and I've had, when addressed with similar issues, some clients have said, no, that's a conflict, send it away, and other clients have said, have you worked on that case? No, we haven't. Well, then there's no conflict. And then the third case is if you've done some work and you have some specialized knowledge in it, then that could be a conflict. So, right. So the follow-up question is whether we are under a duty to contact both clients, both the case that you're currently prosecuting and the other client in which the reference was cited. So it probably would be, on a best case scenario, the best to obviously contact all parties involved and get everyone's approval. However, I can think of a scenario where the client with the reference that was being used to reject the application, if you're not taking any action or making any statements that are adverse to their interests, that I think that would maybe think about that in a different way. That's another factor as well. Yep. Yes.
One thing, and this actually relates to my conflict. My analysis will specialize with the things who argue against. But in terms of the conflict part, you get into a situation. I was talking to somebody about it. They kind of felt like, well, you could argue against that one person that really liked about it. As soon as you're kind of doing that, then you're sell his practice of law. So then, you do argue against it. You characterize a reference, especially if you wrote it. And you're characterizing some term in the claim. The purposes of your own claim.
Right.
And whether that's a problem that you didn't write it and it's part of the application.
On the other hand, are you going to amend your current case in order to avoid characterizing your other client's existing case?
Right.
And so that's why I just want to do the case.
Well, I'm getting a sense of relief to know that everyone else seems to struggle with some of these issues as well, and it's not just something that I struggle with. The factor too that comes to place in a lot of issues too is there's an acronym SWAP, I think, for many devices, size, weight, and power. Everything that we tend to do, we want it to be smaller, less weight, and provide more power. And so you can have basically products from completely different types of applications and clients and whatnot that are all kind of looking towards reducing the size, reducing the weight, and increasing power. And so you have a kind of culmination where everybody's kind of getting to the same end output. And in so doing, potential conflicts can arise when you wouldn't have necessarily even expected it. Model rules of professional conduct that obviously we must also follow. Nebraska and Iowa follow 1.7. It's very similar to the rules proffered by the United States Patent and Trademark Office, so I won't spend a lot of time there. One of the things I kind of wanted to touch on, and this was something too, that the idea is, can we create a wall? You know, so there's most of us here are working in firms, and you know, can we create a wall so that just because I might have a potential issue, my colleague can possibly handle the matter, and we can maintain, both of us maintain our ethical duties. And that follows in this section. While lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by rules 1.7 or 1.9, unless the prohibition is based on a personal interest of the disqualified lawyer and does not present a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm. Well, you know, I think, and this is something that Tyson is going to really analyze in the second half of the presentation, but you know, the question becomes, if you know, clients, you know, within the firm, even though someone might be managing that client, you know, all the clients in a firm are represented by the firm, and so is there really a case in which, you know, if one attorney we all kind of agree has a conflict, can we, by the work of another attorney in the firm, have a scenario in which there isn't a significant risk of materially limiting the representation? So, you know, the kind of the thing to think about is, you know, if there is a conflict in the firm, you know, best case scenario is probably to refer it to another firm. All right, subject matter conflict of interest. How are we going to remove the client? You know, we obviously can refuse to take the conflicting matter or the client. In the instance of where, you know, it might be iffy, maybe we can get signed conflict waivers from both parties. And you know, Ryan's scenario certainly got into that position. As you know, we could certainly try to do that, but you know, as a attorney trying to zealously advocate for those attorneys, it's not necessarily something that we want to do. And finally, you know, can we create a wall? You know, I think it's going to be difficult to try to do so, but obviously there might be a situation or some kind of scenario in which that might be a possibility. So I guess kind of wrapping up, that's my spiel on subject matter conflict of interest. At this point, do we want to open it up to any questions for that section of the presentation? All right, it looks like everybody has complete understanding, and so we're going to move on to another ethical consideration for patent attorneys, and that is the duty to disclose. So for the non-patent attorneys in the crowd and listening to the presentation, when a patent application is filed, there is a duty among the inventors and the counsel who represent the inventors to disclose all known material information that would be relevant to the patentability of your invention in which you have filed the application. And that is something that's pretty unique to, United States as compared to the patent laws in many foreign jurisdictions. And it's certainly a duty that keeps a lot of patent lawyers up at night with worrying whether or not they are in compliance with the duty to disclose. The duty to disclose is represented in 37 CFR 1.56, and we'll, for the sake of brevity, we'll kind of just talk about the relevant aspects rather than going through it in any particular detail. So the first question, the first issue related to the duty to disclose is who has the duty? And as I mentioned, any inventor of a patent application has a duty to disclose. The registered practitioners that are handling the matter also have a duty to disclose. And finally, non-inventors and non-attorneys who are substantially involved in the patent prosecution also have a duty. And that's something that I guess I wasn't completely aware of until I began my preparation for this presentation. In this case, Avid Identification Systems, Inc. and Crystal Import Corp. Kind of factors that might be relevant is, you know, the particular position of the person within the company and his or her control within the company. Certainly the level of communication that they have with the inventors and the development of the product itself, perhaps. Also their relative skill involved in which the subject matter pertains. So oftentimes, particularly maybe in the instance of a small business where the CEO or maybe CTO in a larger business that's heavily involved, in the development of products and is working fairly closely with the inventors, that might be an additional party beyond just the inventor who might be subject to this duty to disclose. Yes, Tyson. That's the great question, and typically what I've seen is that rarely is it found that they are have the duty to disclose. But oftentimes that can be a situation that is pretty precarious because they're often involved in a lot of times the work associated with the information disclosure statements, and they perhaps maybe they don't have a specialized engineering or technical background, but they know what's in the patent. And so while I would say generally they haven't risen to that level, I could certainly see a situation where that would come up to be. And for everyone listening, the question is what about patent paralegals? And like I said, it's been my experience in my review that they haven't necessarily been held to the duty to disclose, but I could certainly foresee a situation in which, or a scenario in which that could be an issue. Okay. Yes.
In terms of the paralegal, I understand that maybe no duty to disclose independently. Wouldn't there be kind of a mapping to the attorney? Wouldn't the attorney should have heard about that? Paralegal relationship, agency.
So the question is, even though the patent paralegal may not have the duty kind of by the natural relationship of the patent paralegal working with the patent attorney, wouldn't there possibly be some mapping? And like I said, I definitely think that would be a possibility under that scenario. And so, I mean, to the extent that the patent paralegal was aware of some references and due to his or her knowledge of the situation, kept them out of the purview of the patent attorney or patent agent handling the matter, I could certainly situation where inequitable conduct was found because of that scenario. All right, so what is the information that must be disclosed? We must disclose known material information that's relevant to the patent application and the patentability of the patent application. And it doesn't matter how the information became to be known by the attorney or the inventor. If, for example, I sent a FedEx box of prior art materials that I can show were received by a particular inventor, and those inventors had a related application, would they necessarily be required to, at that point, disclose it? You could think about how that might come to be. While there is a duty to disclose, there is no duty to search, and so oftentimes inventors and particularly large clients don't necessarily want a search to be performed because they don't want to have to necessarily be required to disclose that information, and so that's something that's kind of unique. Even though we have a duty to disclose everything that we're aware of, we don't have a duty to search. So what are some examples of material information, and what is material information? Well, it's any information that a reasonable patent examiner would be substantially likely to consider important in deciding whether to allow an application to issue. And for most of us, we kind of think of those as prior art issues, or references that were published before our filing date that would relate to the patentability, on the perspective of a novelty or non-obviousness standard. However, it also includes information that would be any information that would be relevant to patentability, whether it be inventorship or enablement. And so, any maybe experiments that were performed that shows that, hey, this invention really doesn't work the way we are claiming it to be. If that document came to be known by the inventor or the attorney and it wasn't disclosed, that would rise to possibly the level of material information. Material information also includes any misrepresentations made to the USPTO. So if you say that you're entitled to small entity fees, but you're not actually available to claim that status, then that's potentially a material information. Can you disclose too much? And that's something I kind of wanted to raise to the crowd. Is obviously there's anything at some level could be somewhat related to the patentability of an invention. Can we just send a truckload of prior art documents to the examiner and just kind of try to hide the one reference which is really damning to us. Thoughts?
I've seen cases where the examiner treats it differently when there is just an overwhelming amount of information that I've provided, you know, whether through intense international prosecution where you have to cite everything that's been cited in international search reports, and in those cases the examiner will basically make a statement that I've considered these documents to the level that I would consider doing a search through well-known databases. And so sometimes you can lose the granularity that you might want an examiner to review the documents if you do provide too much.
That's a great point, and so what he said was that, you know, one of the things is if you do present just a tremendous amount of prior art, there's a couple of things. One, the patent examiner might not necessarily, you know, review those to the level in which they normally would with a more appropriate size disclosure. And also you're potentially risking, you know, at some level, as a patent applicant, you may want to have the examiner particularly consider a particular reference because it's relevant to your application and what you feel are the distinguishing characteristics or qualities that make your application both novel and non-obvious. You know, as we mentioned, examples of material information, relevant prior art, but beyond that, co-pending applications, whether you've filed a number of continuations or continuations in part or have filed foreign, all of those co-pending applications are going to potentially produce some material information, and those might include rejections of similar claims and office actions of similar claims as well. And so that information is all particularly material and should be disclosed as part of our duty to disclose. So if we don't disclose, what's going to happen? Well, that rises to the level of possible potential inequitable conduct. And so if the material information, if the information is in fact material and it's withheld with an intent to deceive, then there's a basis in which possible inequitable conduct can occur. And I think it's interesting that, you know, obviously if you're looking at something that has a very high level of materiality, then in that showing, you know, the level of intent is going to be fairly minimal. So a smoking gun may not need to be found if it's been proven that an attorney or an inventor failed to disclose a very material reference in the prosecution of the application. The intent to deceive, the evidence must show intent at some level. It can be shown by circumstantial evidence. However, you know, general negligence is generally not sufficient. So all of us should still sleep well knowing that, you know, just a mistake is not going to rise to the level of inequitable conduct. Any patent litigators in the house? And maybe you'll be able to speak about this topic. So when does inequitable conduct and when does this always kind of come to rear its ugly head? When somebody has been asserted for patent infringement, the first kind of step in a possible lawsuit is, well, there must have been inequitable conduct by the inventor or patent attorney, because a finding of inequitable conduct will render the patent unenforceable. So you can imagine the situation and the way things work for the non-patent attorneys. What often happens is a patent application is filed, and maybe 4 years down the road, the patent application is issued. And then 5 years down the road, the client sues for patent infringement. And so we have patent litigators now looking to find a way in which to show that my client could not have infringed this patent because this patent should have never been approved, it should have never issued, and I'm sure those attorneys that worked on that application were working in a not nice way. And so now they're doing searches to try to find art that may have been relevant to the patentability of the invention and the patent at hand, and try to make a case that, well, these guys, they knew about it, they should have known about it, they didn't know about it, they didn't disclose it to the patent office, and so patent is unenforceable. So why does that come up? As we as prosecutors obviously just need to make sure that we're careful as we can be in trying to fulfill this requirement. Yes, Tyson.
What I find interesting is you have a patent and you have a continuation out there, and maybe you have found art since that patent has issued, and interesting if prosecutors cited or not citing that in the continuation, and what kind of effects that have on ethics as well.
That's a great question. So Tyson's question related to, he presented a scenario in which the patent application had matured into a patent, a continuation application gets filed and has some, what we'll say is maybe similar claims or similar claim language as to the issued patent, and then at that time becomes aware of a reference that is materially material and relevant to the claims. And so at that point, what action do you take? And Tyson, I'll put it back to you. What action do you recommend in that scenario?
Filing it in an IDS.
File it in an IDS, disclose it.
Maybe supplemental re-examination through another, the patent.
Exactly.
Through a supplemental re-examination.
Yep. So even though the patent has issued, it doesn't mean that it's all incoming. Patents come with a presumption of validity, but it's not all becoming, and it can be refuted. And so what Tyson mentioned as a possibility in that scenario is that whether through a re-examination or possibly reissue, there's some methods in which that particular reference can be submitted and considered by the patent office in order to try to get that issued patent to kind of have the blessing after becoming aware of a relevant piece of art. Good question. Practice tips. So in doubt, I think it's always best to disclose. I think what's really important is trying to develop standard procedures and docketing systems in order to ensure that information disclosure statements are filed correctly and they're timely filed. It's important to, as Tyson had just mentioned, to keep track of those continuations, divisionals, and foreign counterparts that create a lot of additional material information that's relevant. And by doing that and keeping those procedures, you'll be able to disclose all that art that could be relevant, and you'll be fulfilling the duty to disclose. Thank you very much. That's kind of concludes my discussion. Any other questions and concerns at this point?
May I ask, with respect to the duty of disclosure,
Yes.
there's no duty to search, but can you be willfully blind? For example, if you know you're prosecuting the continuation of art, you know the pair patent is in litigation, and legal validity contentions have been served, cited bench prior art, can you say, I just don't want to know about it, it's different from handling it? And is there any kind of obligation, you know, as to what's available to you or your client to inquire about those types of things?
Well, so I mean, I think the standard is if you're not aware of the reference, there isn't a duty to disclose. Now, you the question that she raises is, hey, what, you know, is there ever a scenario that, you know, can you just kind of put your head in the sand and pretend like references probably that actually exist don't exist? Is that a fair representation? And so I think at that level, I mean, theoretically, if it's, let's just say, that obvious or everybody knows about it, then it shouldn't be that difficult in that instance for the examiner to find art that will teach the same level in which you might be referring. So from that aspect, I mean, it's whether or not you're aware of anything that's material that wouldn't necessarily have become known to others. I think that would be, but I definitely think if there's a situation though in which it can be shown that, you know, if you're not aware, you really should have been aware, and if it's really material, I do think that could rise to a possible inequitable conduct. Great question.
Any thoughts on dual or two hats, prosecuting and litigating, being the prosecutor and then being the litigator for that patent as well?
My thoughts are, as the people here can see, I don't like to wear ties, and I don't go to court, and so I keep my single hat, and will probably do so until I die. I do think it'd be difficult to both do patent prosecution and patent litigation for that reason. Great question. Do we want to take like a 5-minute break? Okay.
All right, I want to thank Chad for that portion of the presentation, very insightful. And one of the interesting, at the very end we were discussing having dual hats with regards to being a patent prosecutor and a patent litigator. One has to keep in mind that that prosecutor may be called as a witness at some point down the road, so you want to be aware of that. So in any case, it's usually better to be an independent litigator for a patent and an independent prosecutor for a patent. So we'll transition to A very important case that many patent prosecutors, all patent attorneys, probably across the United States were keeping their eye on. While it's a state court decision, it still had a lot of bearing in whether or not what ethics mean at this kind of juncture. So it's Malling versus Finnegan, Henderson. Finnegan is a very big full-service IP law firm out on the East Coast, worldwide, but primarily on the East Coast, and they prosecute a lot of patent applications. They litigate a lot of patent applications, and so as we'll kind of get into, we'll see some interesting fact scenarios that really play on what Chad had just previously discussed. And really at the point, we'll go back to Chad's presentations of canons 5, 6, and 7 to really hone in. And this case was so interesting as well in that there were a lot of friend of the court briefs submitted on behalf of Finnegan, because if the outcome of this decision went the other way, subject matter conflicts would have been very, very difficult, and as we'll see. So without further ado, we'll get in there, and if anyone has any questions, please let's discuss points, or if you have anything, I'm more than happy to discuss. So just interrupt, and we'll go from there. Question at hand: whether there is an actionable conflict of interest, and this is under Massachusetts rules of professional conduct, but as we learned earlier, 1.7 is pretty similar throughout the United States and also with the USPTO. But under Massachusetts rule of professional conduct 1.7, when attorneys in different offices of the same law firm simultaneously represent business competitors in prosecuting patents on similar inventions without informing the clients, either client, or obtaining their consent to the simultaneous representation. So is there an actionable conflict of interest when you as a law firm, maybe in different offices, take on competitors, business competitors on similar technology? And one thing I'll also note as well is if you're reviewing the opinion, my numbering is a little bit different than what the numbering in the Massachusetts Supreme Judicial Courts. That is because in 2015 they updated the rules of professional conduct. The essence of it is the same, but if you see some numbering like A1, A2, that's where the difference comes from. But the substance is still there and it's exactly the same. Background. Malling engaged attorneys in Finnegan's Boston office in 2003 until 2009. At this time, Finnegan performed legal services for filing and prosecuting patents for screwless eyeglass technology, including a screwless eyeglass hinge block design. And real quick, also in these materials, I have included the first filed Malling patent, and then also the Masunaga patent as well, or one of the Masunaga patents as well, so that we can you can see the difference if you want, or see if truly how similar this technology was and what it really is. So, but getting back to the case at hand, Finnegan was successful in obtaining 4 separate patents for Malling. During the same time period, the DC office of Finnegan represented Masunaga Optical Manufacturing Company that sought patents for screwless eyeglass technology. This kind of reminds me of Matt's fact pattern just a little bit, but certainly it's interesting that there's a fact pattern, and Matt from the audience shared it with Chad a little bit earlier when we first really kind of got going on this. So we're going to see how this case turns out. Here's figure 1 from the Malling patent. And then, so as we see here, what you'll notice is the court really focused on this hinged block design, and it's referenced as reference number 4. So if you take a look at number 4, but you'll also see in figures 2 through 4 of the mailing patent, that's really what the technology is directed towards, is this hinged block design. So here's claim 1. An eyeglasses frame assembly having, and I bolded for the purposes of really hitting on what the invention of this is. Temple arm hinge block for an eyeglass constructed and arranged such that the eyeglass's temple arm can be selectively and replaceably removed from said temple arm hinge block by application of a predetermined amount of torque, wherein said temple arm hinge block comprises a groove for receiving a portion of said first end of said temple arm, and so forth. So really, at the end of the day, we see that the claim 1 directed to, while it introduces eyeglasses frame assembly, the temple arm hinge block is what mailing was going after with Finnegan through their when they're prosecuting this patent. Real quick, also with regards to the 4 other patents of mailing, the 3 others that were subsequently filed and issued into patents were direct continuations based upon this original patent. So mailing actually, and what we mean by continuations for anyone out there that isn't sure, you're filing the exact same patent application as you previously filed. So imagine the same exact detailed description, same drawing, same subject matter of this patent that we're seeing right here, except that we might amend the claim coverage to amend, or we're changing the claim coverage in order to either broaden up the claims or overcome some art that we might have become aware of, or whatever the reason. So this is a direct lineage to this patent, and so I just wanted to kind of bring that to the forefront as well. Here's one of the Masunaga, and what I'll say is the Masunaga, they had a number of patents previously. Previous to when mailing engaged Finnegan, there was a number of patents out there on various screwless eyeglass technologies, and this is one of them. The reason I picked this one is because this is one of them that was cited in the IDS that we'll find out here in a little bit in a mailing case, and I'll give you that kind of prosecution history here shortly. So here's claim 1 of that patent. As we see, let's kind of go back. The first introduction is a temple arm hinge block for eyeglasses constructed and arranged. Instead of this one, which is an earlier patent, a wire form frame member having opposite end portions, and then a pair of lens holding means arranged at the center were in said frame, and then I'll just jump to the bottom real quick, wherein each of the said adjusting bent portions has a U-shaped configuration, and both leg portions of each of said U-shaped adjusting bent portions are arranged to overlap as viewed from a front side. So in this, what the takeaway from this is that there's different technologies. While they're both eyeglass, screwless eyeglass technologies, what we see here is maybe the claims are a little bit different, or the technologies of Masunaga and mailing are just a little bit different. And so we're not, we got to keep that in mind in this lens of exploring this case. So the allegations, and we'll get into what the procedural history is here, but when mailing submitted his complaint, Finnegan belatedly commenced preparation of patent application in or about 2014. He even goes as far as saying inexplicably took 14 months to commence preparation and to file this patent application. So in mailing's eyes, once I engaged them, it took a long time for Finnegan to actually commence the work of these patents. Mailing also alleged that Finnegan filed patent applications for Masunaga more quickly. He paid Finnegan in excess of $100,000 for services and invested millions of dollars to develop his product. And he would not make that investment if Finnegan disclosed its conflict of interest and/or if it disclosed its work on the Masunaga patents. He also alleges that Masunaga's applications are very similar to the mailing applications, and Finnegan knew that it was performing work in the same patent space.
So real quickly, we have to go back and remember that Finnegan is a huge, huge law firm. Offices in Boston, D.C., probably San Francisco, any place. So, wow, we have to have a real highly developed, possibly, way to identify these conflicts if, if we're going to take on these, the clients in similar space, because they need to know, based upon mailing's allegations, that this was the same patent space, and so forth. So we'll further go on to what was alleged in the complaint. He was harmed by Finnegan in 2008 when Finnegan declined to provide him with a legal opinion that addressing the similarities between the Masunaga patents and the mailing patents. So once he became aware that they were working on the Masunaga patents, mailing went in and said, hey, take a look at my patents and compare them and provide me a legal opinion of the differences, or what's the differences between the Masunaga and the mailing patents. As far as we can tell, well, there was no opinion, no legal opinion provided by Finnegan. What I assume happened is Finnegan said, no, we'll pass on providing you with this legal opinion. Because of Finnegan not being able to provide him this legal opinion, he was unable to obtain further funding for his product. Now, I'm not sure why. Maybe he could have probably went to a number of other law firms to get this legal opinion, but because Finnegan didn't, he wasn't able to obtain funding. So thus, the product was otherwise unmarketable on account of its similarities, resulting in diminished value for his inventions and his products. In summary, the failure to disclose this alleged conflict resulted in great harm and tremendous financial hardship for mailing, and essentially his business, I guess, ceased to exist. And what I'll also say real quick is that the patents of mailing are no longer, he failed to pay the maintenance fees, so they lapsed and went into the public domain. So real quick here, the procedural history, what's going on. Of course, mailing filed a complaint. Finnegan moved to dismiss complaint for failure to state a claim under 12b-6, similar to, of course, all 12b-6s of civil procedure. Motion was granted in that state court. Mailing appealed, and then I always get the Supreme Court of Massachusetts a little mixed up, but it's Massachusetts Supreme Judicial Court transferred this case on its court's own motion. Really quickly, moving back to what mailing was alleging. So he says, hey, everything happened here. Here's my 4 bases of relief. There was a breach of fiduciary duty, legal malpractice, unfair or deceptive practices, and inequitable conduct before the USPTO, and kind of goes back to a little bit of what we were talking about with Chad in his presentation of maybe the inequitable conduct might have been that Finnegan didn't cite the Masunaga patents in the earlier, didn't cite the earlier Masunaga patents in the mailing patents, but for the very, very last one. So really quickly to what the court is deciding. The court indicated that each of those accounts of mailing, so there's breach of fiduciary duty, legal malpractice, unfair deceptive practices, and inequitable conduct before the USPTO, they all hinged on the existence of an undisclosed conflict of interest that arose from Finnegan's representation of both mailing and Masunaga. So the court said we have to answer the question whether there was truly a conflict of interest in order to maybe address each of these 4 claims that these bases for relief. And what I will say also is that Finnegan, in one of their briefs, they stated, even if all this happened, what harm became of mailing? Did he get any worse patents than he would have been entitled to, or whatever the case? So part of what Finnegan's brief was stating is, did any of this actually rise to harm mailing because of this undisclosed conflict of interest or alleged conflict of interest? So real quickly, what we're going to do is here is the Massachusetts Rule of Professional Conduct 1.7. A lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client. So we're going to see how the court addressed this piece, 1.71. Well, first, it decided to look that these types of matters involve subject matter conflict. And as we kind of talked about earlier, it's it's similar technology. So if we have what the court said in its opinion, that subject matter conflicts do not fit neatly in traditional conflict analysis. But simultaneous representation of clients competing for patents in the same technology area is generally referred to as subject matter conflict. So by its nature, being a patent prosecutor, you're trying to get a property right for your client. If you get that property right, you're taking it away from potentially another client down the road. So every patent you get is presumably or taking away more patent rights so that you can't potentially get for these in maybe the similar space. So if client A gets a patent, necessarily then client B can't get a patent covering the same invention. That property right has already been taken away. Mailing advocated for a broad interpretation, rendering that would say that all subject matter conflicts were per se violations, or in and of itself, if there was a subject matter conflict within your law firm, that was a per se violation. What we're going to find out at the very end is court held that subject matter conflicts do not, standing alone, constitute an actionable conflict of interest that violates Rule 1.7. So again, this was all, we have to remember that this was all allegations that mailing, because it didn't get very far within the court system, mailing filed his complaint, Finnegan answered, moved to dismiss, and so what we're seeing here is that the court is only going to be reviewing these I guess these allegations of mailing and to see if those allegations would amount to sufficient to allow them to take on that case and decide the matter. So adverse representation under Rule 1.71. What does it mean to be directly adverse? Well, representation is directly adverse when a lawyer acts as an advocate in one matter against a person that the lawyer represents in some other matter, even when the matters are wholly unrelated. So a firm cannot represent client A in one matter and then represent plaintiff against client A without the consent of both clients. Otherwise, you'd be directly adverse. So you're taking, really at the helm, or what you really want to think about this is that it's in the realm of legal. That you always, it's going to be related to legal representation or the legal rights. That if it's an adverse representation, if it's a business, if they're directly competing because of business, then that's what we're going to see. But you can't directly represent a client in a legal matter against another client without their consent of both clients. As the court analyzed here, mailing and Masunaga were not adversaries in the traditional sense. Yes, they were both directed towards screwless eyeglass technology, but each appeared before the USPTO in separate proceedings to seek patents for respective screwless eyeglass devices. So we're going back, the hinge block design versus the frame. So mailing was going for the hinge versus Masunaga, which was going for a variety of other purposes. They're both in the same screwless eyeglass technology, but we see here the court said that these are separate proceedings, separate, maybe even separate inventions. So they're separate inventions, but mailing contended that they're directly adverse because competition was in the same patent space. But direct adverse adverseness requires a conflict as to the legal rights and the duties of the clients, not merely conflicting economic interests. So this goes back. It has to involve legal rights and the duties of the clients to perform. It doesn't necessarily mean it's going to be a conflict if you're representing two clients and it's a conflicting economic interest. The court cited Curtis v. Radio Representatives. In this, the U.S. District Court for the District of Columbia found no actionable conflict when law firms simultaneously represented clients in preparation and prosecution of applications for radio broadcast licenses from the FCC. So in this, we had a client A, client B. They both went to the FCC. They hired the same law firm to file applications to seek broadcast licenses from the FCC. Court said the conflict, this Curtis court said conflict could arise if clients seeking broadcast licenses under the circumstances where objectionable electrical interference existed between the two stations. However, in this case, there was no facts or no allegations that once the applications were approved, that there was electrical interference that were existing between the two stations. So the court found that Curtis was analogous because they were not competing for the same patent, but rather different patents for similar devices. So again, Curtis, we're filing for a patent for a broadcast application in one, I guess, band, and there was another for another frequency band or electrical interference or electrical signals. The conflict could arise under different facts. So one important note, as of March 16th of 2013, the AIA, American Invents Act, was implemented. So these patents, of course, are pre-AIA, and so the analysis is done under a pre-AIA context. But if two patent applications were filed prior to March 16th of 2013 are identical or obvious variants of each other, such that an interference proceeding could be instituted. And real quickly, an interference proceedings are meant to assist the director of the USPTO in determining priority, that is, which party first invented the commonly claimed invention. So before in the AIA, it was a first to invent system, meaning the first inventor to invent had rights to that invention. Even if someone filed an application before that and it was subsequently invented, the inventor who first invented, even if he was last to the patent office, could show that he was entitled to that invention or that property rights in that patent. And so that was what an interference proceeding necessarily allowed them to do, is to determine who is the actual inventor. But Finnegan, as the court noted, acting reasonably, believed that such a proceeding was not likely since the legal rights would have been in conflict. So here we take a look at that. Finnegan, acting as a reasonable patent attorney, believed that it would have been a conflict, that the conflict could arise if Finnegan did act reasonably, that such a proceeding was likely since legal rights would have been in conflict. So let me just state that if Finnegan believed that the Masunaga and the mailing patents, that an interference proceeding was likely, then this would have been deemed a conflict of interest. However, of course, mailing did not allege that the claims are identical or obvious variants to each other. The patents issued for his application, there were patents that issued for both his applications and the Masunaga applications, and there was no allegations that an interference proceeding was instituted. One side note, we're going to quickly go back to when Finnegan did, try and obtain, so mailing tried to obtain a legal opinion from mailing. So this is a potential area where a non-litigation violation could exist under 1.71. The subject matter conflicts can give rise to conflicts in non-litigation context. A lawyer would be precluded from advising a client to his rights under a contract with another client or the lawyer, of the lawyer, because it involves legal rights and duties of two clients to one another. So you can't have two clients that have a common contract between them, and you can't go in and let them know of what their legal rights or obligations or what's required of them under that contract if you represent both clients and it's a contract between the two. A conflict would have likely arose in 2008 when Mailing sought a legal opinion from Finnegan regarding his exposure to the Masunaga patent. So essentially what this court's saying is, if Finnegan did write a letter saying, yeah, your product or your patents in light of this, or citing the differences between Mailing's patents and the Masunaga patents are different for this, or if Mailing was solicited an opinion from Finnegan saying, hey, am I liable or do I infringe these patents of the Masunaga? That would have been likely a conflict of interest because providing this opinion would arguably have rendered the interests of Mailing and Masunaga directly adverse. But there are no allegations in the complaint that said that Finnegan agreed to provide such an opinion. Questions on being directly adverse to one another or any combat stories out there? Wonderful, wonderful. We will transition to 1.72. So, a concurrent conflict of interest exists if there is significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. So, essentially, this prohibits the representation where there is not a directly adversarial relationship, but you as a lawyer would not be able to consider or recommend or carry out an appropriate course of action for the client because you'd be limited in what you can advise that client on. So if you'd be further hindered from letting them know all of their alternatives, opportunities, solutions to the problem, you're not able to do that because of some prior relationship or relationship. This would be one of those that it's not directly adversarial, but you're limited in providing your legal analysis or legal opinion to the client to the fullest and extent zealous advocacy. So the critical inquiry here is whether the lawyer has a competing interest or responsibility that would materially interfere with that lawyer's independent judgment in considering these alternatives or foreclosed courses of action that should be pursued on behalf of the client. Under this, Mailing alleged that Finnegan was unable to protect his interests in Masunaga's and selected to protect Masunaga at the expense of Mailing. In other words, Finnegan got Masunaga patents. My patents might not be that great because he wasn't able to protect both of our interests, and they selected to file more quickly, prosecute more. Actually, Finnegan, one of the allegations, and this is a quote, that Finnegan pulled its punches and got more for Masunaga as compared to Mailing. So he alleged that Finnegan obtained more for Masunaga. But here's a case that's pretty much kind of on point, and it might actually go back to a little bit of the scenario that we discussed, or it's actually close with the fact scenario that we discussed earlier in Chad's presentation. The court cited Sentinel Products versus Platt. This was a conflict of interest from prosecution of patents for competing clients. It was actually a company and a former employee. The firm's attorneys testified that they thought the applications overlapped, and that they were unable to discern a patentable difference between the applications. That's not very good testimony on behalf of anyone. And a patent for a former employee issued first. And I just want to stop here because this is actually an interesting fact pattern that I've been trying to figure out, and I'll put it out to everyone, and I don't know if the fact pattern is incorrect or what. I've actually looked into this because this is from the Sentinel. On a motion for summary judgment, the court concluded that the law firm filed applications with the USPTO for Sentinel, and then 2 weeks later for the former employee. So then firm's attorneys had testified what we just had actually, that they overlapped and couldn't discern a patentable difference. But a patent for an employee's application was issued first. So Sentinel, the company, under this fact pattern, had an application that was filed. But the patent for the employee's application was issued first, and the Sentinel's application was rejected after the USPTO, and this might be what's important, found it conflicted with claims contained in the employee's patents. The only thing I can think of is maybe that it's an interference proceeding, or that the employee's application was actually the one filed earlier. But I've tried to look. I've looked at the whatever Google would provide me as an extent as that far. But I found it interesting that the patent for the employee, even though it was filed later in time, it issued first, and therefore the patent for the Sentinel. Oh, go ahead.
Was the employee an inventor of Sentinel's patent application?
The facts don't. I assume. Yeah, they never said. The question was the employee for. Was the employee, the former employee, actually an inventor for Sentinel? The fact pattern didn't say what it was, but really what they really kind of focused in on, and here was it that Sentinel rejected after the USPTO found it conflicted with claims contained in the employees. The firm narrowed the claims in Sentinel's application to avoid conflict with the former employee's application. And thus, USPTO issued the Sentinel patent with narrower claims. So what we have is same law firm representing former client, representing company, apparently on very, very similar subject matter, so much so that the former employee's patent claims necessarily might have even read on a lot of what the products were going for, not read on the products, but Sentinel's Products Corporation, their application was rejected in light of this, and so the USPTO issued claims once the through patent prosecution, the firm narrowed the claims in light of it and said, here, this is, and this is what the court referred to as claim shaving. The court found that this clearly implicates 1.72 because it creates a question of fact as to whether courses of action that reasonably should be pursued on behalf of the client were foreclosed. So did the law firm not provide enough legal opinion that of alternative courses of action? Did the law firm not let Sentinel know, no, that yours is different because of this? Or, so basically they were boxed in because they had competing clients in competing patent space that were very, very close, if not the same invention. And so this clearly implicates 1.72 per the court's analysis. So getting back to our allegations, mailing failed to provide, and this is the court, failed to provide more than speculation that Finnegan's judgment was impaired or that mailing obtained less robust patents than if he had been represented by a conflict-free counsel. So again, this gets back to the question, were mailing's patents hindered? Well, there was Boston attorneys working on his. There were DC attorneys working on Masunaga's. So there's no fact scenario where it states that they said, hey, we should try and actually focus in on this hinge block design, not the overall technology or the eyeglass technology, but let's just focus in on this hinge block. I could see where potentially if the Boston attorneys at Finnegan knew about the Masunaga patents and said, you have mailing come to them and say, here, I have this brand new eyeglass design, they might have been foreclosed from being able to say, well, let's not go on the whole eyeglass design because secretly I'm aware of this Masunaga patent. Let's just focus in on the hinge block design. No, everything that we see here, the allegations state that Mailing believed that his technology was on the hinged design of his, and that's what the patent claims were directed towards. There was no indication of whether the claims contained in his applications were altered or narrowed in light of the Masunaga applications. And what I will say is actually I went into the prosecution history of mailing. As I mentioned earlier, 4 patents were issued. There was the parent case, and then 3 continuations that were filed on behalf of mailing after that. Went into the IDSs to see when or if Masunaga showed up on behalf of either the examiner finding this, Masunaga, or any of them, because what I will say is that there were plenty of Masunaga patents or patent applications that have issued prior to this point. So the examiner would presumably have been aware of some type of technology or the space that Masunaga was playing in. The only place that I found a Masunaga patent or patent application cited reference, and there was a few of them, was in the 4th continuation. So it was around 2008, right around, I probably, if you were going to ask me about the time that mailing indicated to Finnegan, hey, you're representing Masunaga. And, you know, so that's my presumption that that happened. But what I will say is it was cited once that continuation was filed. The IDS was filed almost contemporaneously. And so the examiner was aware of the Masunaga art out there, and in no way did the examiner utilize the Masunaga patents to cite against them. It was actually a Conway as a 102 and a 103 reference rejection. So at no point did I see that Masunaga was cited against any of the patent when they were prosecuting the mailing patents. And so what I will also see is that, you know, there was no allegation that Finnegan delayed filing his patent application to ensure the success of Masunaga. So, as we see here, the court indicated that there were too few allegations to indicate such a conflict was foreseeable. Finnegan, at the time, would not have been able to foresee that, hey, that there was an opinion needed or a potential legal opinion needed between 2 competing clients. The court did say that it is possible that Finnegan should have declined, and maybe if there was more specific allegations, it might have turned a little bit differently, but those allegations weren't in the complaint, and the mere possibility of subsequent harm does not itself require disclosure and consent. And there was simply just too few facts for which to infer that Finnegan reasonably should have foreseen the potential conflict in the first place. What I will say then also, this is kind of letting us, we have to identify the conflict of interest, or the court at this point indicated the importance of law firms being able to identify a conflict of interest. You know, there's a very important that there's an adequate conflict check in place for law firms. What constitutes an adequate conflict check is a complex question. And what I'll say here is that a member of this court observed, and this is going back to the opinion, against a backdrop of increasing law firm reorganizations and mergers, lateral transfers, and the rise of large-scale firms that transcend state and national borders, the issue of dual representation is one of a multifaceted overtones and novel complexity. In other words, we have to, you know, have good conflict checks in place, because there's, you know, subject matter conflicts. While they're not per se violations, we very well could find ourselves in one of these areas where it's not the Curtis, but it's actually the Sentinel fact pattern. I think the next point, and the question was, did the court provide any answers on, other than just providing gibberish? That is an exact recitation of what the audience member. No, the court didn't provide much other than gibberish, and I'll actually, since you brought that up, I'll just, nothing we say here today, however, should be construed to absolve law firms from the obligation to implement robust processes that will detect potential conflicts. The court has not a minimum protocol for carrying out a conflict check in the area of patent practice or any other law. However, no matter how complex such protocol might be, law firms run significant risks, financial and reputational, if they do not avail themselves of a robust conflict system adequate to the nature of their practice. Thus, it is clear that we must have a robust conflict system that is adequate to protect the nature of our clients. I think that in the audience members' eyes, this would be considered gibberish because there's no minimum protocol for carrying out the conflict. We just must know what an adequate conflict is. At this point, let's open it up for discussion. What is an adequate conflict check that we are implementing or should implement? Anyone have any ideas? Oh, wonderful. Also, this might be time for anyone out in the webinar as well if they have any suggestions as well, because we will be happy to hear any suggestions that anyone has. Everyone has a wonderfully adequate conflict check system. An audience member, oh.
National, 50 offices around the world, that's, I wouldn't want to be part of that. It's obviously a high-level database searches.
Yeah, no, one of the audience members, being a small boutique firm, oh, yeah, as the audience member stated, it's much easier to identify as a small boutique firm of 8 to 10 patent attorneys, or actually any attorney in a small law firm, because we're probably aware or even intimately aware of what clients we're working for or our colleagues are working on. So it's much, much, much easier to identify a potential conflict in those, because let me say that there is a number of, of subject matter conflicts. The way that I think about it is, if you're working for a memory design company, and what I mean is DRAM or SRAM or any type of memory out there for computers, you can see that there are a number of companies working on different solutions for different types of memory. There are some that are trying to improve the semiconductor processes to create these, or you're actually trying to develop a controller that is more efficiently communicates with the processor. So in those sense, if you have two companies, one directed towards maybe the controller aspect and one towards the actual construction of the memory, you see that as more of a subject matter, it's presumably a subject matter conflict because they're in the same area, but this fact pattern leaves it to be that you could necessarily represent both clients because they are in different areas of memory. But certainly, as the audience member suggested, yes, small boutique firms are much, much easier. When you get a little bit larger outside of the 8 to 10 attorneys, you might have to have a sophisticated database or employ specialized paralegals in order to allow them to more adequately go over and send in when a potential client comes in, have them cross-check and make sure, because even here in Omaha, there's a number of laterals that continue to move between place to place and might bring their clients with, and pre-existing clients might conflict and so forth. So while it doesn't define a minimum protocol, we need to have an adequate conflict check in place. Chat, please.
So, new client comes in and wants to disclose his or her invention, and it's possibly similar to something that's already been done, but like you said, I agree with it. Some kind of at least database system to do a check, or you're just going to try to do a keyword check based on a description of the invention, because at that point, particularly if it's a small client, you don't have a lot of, you have no idea what the A lot of data to cross-reference against.
Yeah, the statement out in the audience was that essentially there is some troublesome. What is that database going to look like? Is it going to be searching on keywords? Because maybe some small client comes in and gives you just a general overview of what the technology is, and you're maybe not aware of what someone has done in the past for your law firm, or what they're currently working on. So is it going to be uploading your current patent applications to be able to cross-check on a keyword search? That also, and it brings up to my thinking that what about you don't necessarily know, you'd be able to quickly identify if it's a subject matter conflict, but if you don't go a little bit more in depth, you won't know if it's actually a true conflict, because there might be small inventors, small clients might come in and they might not truly provide you with what you adequately need to know, and then you maybe come down the road. So what is that going to be? It does seem to be that it has to have some type of database. Would it be a keyword search? Yeah, there's just a lot of issues, and I think that courts wrestle with that, and really depends upon the fact pattern. And I guess you have any thoughts on maybe what minimum would be, or?
Unfortunately, I think my system that I'm familiar with is pretty antiquated and relies on word of mouth, which leaves a lot of solutions don't be part of the
The solution proffered was that don't be a part of a multinational law firm, which I think is actually a very probably a good way of thinking about it. Oh, yeah, please.
How much information do you get? Because you never want to get anything that's confidential, to be able to run that type of subject matter conflict. I'm a litigator, so just who are you adverse to, gets me a lot of the way there. But in the patent world, when you're trying to think about those subject matters, how much do you let them talk to you?
Yeah. Before you can. Yeah, the question, the statement on the table is how much do you actually let the client divulge before saying, hey, maybe stop. There's a potential conflict of interest, and that's actually a very good question, because client, you have a duty to those potential clients as well, not to divulge potential information that they may provide you. So it really is one of these questions that I think that you want to be in a small boutique firm and not the multinational firm, so if tell them to stop real quick. Ryan.
I run into that a lot. It's on the side of things, on the side of things. Usually, like when a client calls and they start giving me an overview, I'll stop them, and then I'll ask directed questions. Say, just can you hold off? Does your technology relate to this area? And if they say yes or no, then I move on. And I usually clear that process first. And if they say it's an area that I know that I have a problem with, then I usually come into that. So I usually tell them to hold off, and then I ask very good questions, and then I pay a lot of it at that point in time.
So the solution that was just stated, or one of the solutions, I'm sure of many, was if a client calls, you're fairly aware of what your client base is, or potentially if you're a small boutique of what the other attorney's client base. So if they can just provide you a general overview, and if that raises a red flag, then potentially what you'd want to do is maybe stop them and then ask directed questions. Those directed questions might be, does it relate to this specific technology? So for example, if it's in the oil industry, is it specifically directed towards the collar or the wellbore, or whatever the case is? But you'll ask directed questions to the technology that you're familiar with, because their answers of yes or no may be able to provide you insight into whether or not, hey, this is going to be falling in pretty much to the application I wrote yesterday or last year, and versus no, this is a different type of area within the oil drilling industry. So that is, you know, one way to kind of resolve the issue is to allow asking directed questions. Chad.
A question that came in from the web was what minimum conflict check is necessary to satisfy your malpractice insurance?
The question on the floor is, what minimum?
I'm not sure if he represents a malpractice insurance.
What minimum standards for conflict check to satisfy the malpractice insurance? I maybe not be in the position to answer that since I don't engage with the malpractice, but if someone out there, out in our audience, has an answer, Ryan.
Usually they ask you to identify what your system is. They aren't, typically what I found is that they aren't trying to identify that you have particular things in place, at least our malpractice insurance carrier, that's not how they handle it. They just want to know what is your system for and typically what we say is if you have a way of querying everyone in your firm about a particular subject matter that's coming in, and I mean even you think about you put a title onto a folder, you generally put the title, you identify some type of subject matter, put it on the folder, it sits in your Microsoft file database, and you can very easily query that. So I mean usually if those two columns, at least I found that's pretty good. That's a pretty good way to identify.
One of the answers out there is that someone familiar with the insurance side of or engaging with malpractice insurance is that the question that some malpractice insurers will ask is, what is your system? So making sure that you have a system and maybe be able to explain what that system is to your insurer would be the important piece of this. So for example, and this is something I read a couple of years ago as well, is that do you have engagement letters? Do you have disengagement letters? What is the actual protocol that you engage in when you query if a new client's coming in? For example, do you make sure to broadcast it to all the potential or the other attorneys within your firm? And so these are all making sure that you maybe have a documented protocol and ensuring that you have sample engagement letters, sample disengagement letters, sample, the conflict checks that you have within maybe an Excel spreadsheet of titles listing each of these, and so that maybe you have a common Excel spreadsheet that lists maybe general subject matter of what it is, and then you can cross-reference it once potential clients come in, so you have a master list that each of the attorneys can kind of check against as another another way of meeting those minimum requirements. So was there any other questions that I missed that came in via, that was the only one? Okay. And if there's any others on the webinar, please let me know if I missed it. All right. So really, in conclusion, we find that the court here indicated what possible actions that could result in a conflict of interest. And remember, we had 1.71, which dealt with being directly adverse. Are you representing client A and client B who's also in an action, maybe an unrelated legal action, but it is, they are against client A? If that's the case, and what we saw previously is that subject matter conflicts aren't necessarily going to be directly adverse by just being a subject matter conflict, but drafting patent applications that could provoke interference proceedings really, and let me just say that, as I mentioned before, interference proceedings are pre-AIA, so March 15th, 2013 and before. So there are many patent applications still out there and the ability to file many continuations out there. So this very well could be, but this court only addressed the pre-AIA. Now there are derivation proceedings, and derivation proceedings are related to the AIA, which is first inventor to file system. So it's more of a race to the patent office, AIA versus pre-AIA. So interference proceedings pre-AIA, AIA. If you draft a patent application that could provoke an interference proceeding, you could be found to be directly adverse. Issuing that opinion letter between competing clients. So not that you just actually prosecuted patents, but are you providing a legal opinion of saying what your rights are, what your legal rights are, what they aren't, in light of that other client, even though you've obtained patents for both of them. So issuing opinion letters, bad. The claim shaving. Again, this is the material limitation. So 1.72, where is your judgment altered or prevent the representation or pre-representation of someone, alter your ability to provide alternative solutions or other solutions to what could potentially happen. And so in this instance, I give the claim shaving, and that was, again, you have very similar, and you have actually attorneys within your firm that testified that we did not see any patentable difference or discern any patentable difference between the two, but potentially we have this claim shaving where you alter the claims in light of another client's patent, could potentially raise the issue of being a conflict of interest within the subject matter conflict. So with that, I'd like to open it up. Of any war stories, anyone have any further questions? This was a lot. Again, this was in Massachusetts, but it was something that I think most patent prosecution attorneys really were sweating a little bit until this just got decided on December 23rd. So I guess we can think of it as a Christmas present for patent prosecutors that came down. Questions, comments, concerns? Ryan?
Did they mention anything at all about the ultimate outcome of prosecution that having a retroactive effect as to whether or not there was an equitable conduct that occurred? So you can imagine a situation where the patent attorney, has a reference assigned against them as their own client, let's say, and if they claim shave, they're in trouble, right? They claim shave, they get allowance. But what if they don't say anything at all and they get allowance? Does that necessarily clean the dirty water of inequitable conduct? And this kind of just tacks on my question prior. Did they mention anything? Did they give any merit to the ultimate outcome of the prosecution to say that inequitable conduct didn't occur?
Essentially, I guess the question was there any further discussion about potential inequitable conduct in light of?
Well, did the success of prosecution having the claim shave, was that a factor in that outcome? Was that a factor in them going back and say, even though there may have been a conflict at that point when it first happened, the fact that it didn't end up, you didn't end up having to cause any difference in the claim, cleaned the dirtiness of the inequitable conduct?
Sure. So the question, to summarize it, was, did the court address any inequitable conduct that might have happened? Was it cleaned since there was no claim shaving, or that Masunaga's patents were cited in an IDS, but they were never cited by the patent examiner during examination to say that this is prior art? Certainly implicitly, they didn't necessarily explicitly state that, but the tenor of this is that mailing did not provide sufficient allegations. His allegations included, I received 4 patents, and in nowhere in that did he say that due to those 4 patents were modified in light of Masunaga, and so they didn't directly address the inequitable conduct of whether or not it cleared inequitable conduct, because near the end of what I'll say is the court made some statements that maybe Finnegan shouldn't have taken this case on, that there could have been, but the only thing that this case really hinged on was there was insufficient allegations by mailing to show that the representation of Masunaga resulted in something bad for mailing. But I could certainly see an instance where potentially, they didn't do the foreseeability. So, I mean, there could be the potential if you foresee that possibility.
It was probably, if you're in that scenario, it's probably foreseeable at that time that it's going to cause a conflict, but can you get rid of that foreseeability by pushing through, and then that inequitable conduct goes away? My thought would be is that no, that if it's foreseeable at that time, even though you can be successful without addressing it, it's still, you probably should have parted with it.
I agree with that, and the question or the statement was more that if it was foreseeable at the time that this potentially could have been a problem, but you got a clean record anyway, did that absolve any of the inequitable conduct? I could definitely foresee under a different fact pattern, or a fact pattern maybe even similar to this, where the court said, hey, law firm, it was foreseeable that something down the road could happen. Therefore, if you foresaw it, but just because it resulted in actually good patents because, hey, you got the luck of the draw that the examiner actually didn't cite this against you and didn't result in claim shaving, I definitely foresee, based upon this opinion, that it definitely could be a fact pattern that says, if you foresaw this, because what I will state in this this opinion is that, in part, the court focused in on that there was no foreseeability that Finnegan would have to issue a legal opinion against those two. That was a statement, or summarized a statement, but basically one of the things that they focused in on in this opinion was that Finnegan did not foresee the opportunity that they would have to issue a legal opinion that would result in the modification of either a legal, potentially with conflicting legal between mailing and Masunaga. So definitely I could see that if it was foreseeable that this could potentially happen, but nothing happened, that could still be deemed inequitable conduct. We have 2 minutes more of fun if anyone wants to partake. Otherwise, I truly appreciate everyone coming out in the webinar audience and the questions that were asked. Very fruitful discussion. And if anyone has any further questions, please feel free to reach out to Chad or myself. We'll make sure to look into those in a deep analysis type way. So thank you to everyone.
Thank you.